This is the Dublin European Law Institute podcast, produced at Dublin City University. I'm your host, Ian Cooper. CATALYZE is a podcast series that shows how the EU is acting as a catalyst for change amid unprecedented global turbulence. It is an expert-led discussion of how the EU is facing the fundamental policy challenges of 2025. Each episode is going to focus on one particular challenge, and today we're talking about Brexit and its aftermath. In particular, we want to talk about how the EU relates to its closest neighbours. So that includes the United Kingdom, which is an ex-member state, having left in 2020, but also Ukraine, which is a candidate to join the EU in the future. So, to unpack all this, I'm joined by Jasmine Faudone, a PhD researcher here at DCU. She works on Brexit as it relates to Northern Ireland. Jasmine, welcome.
Good morning. Thanks for having me.
It's a pleasure. So, Brexit. That actually happened more than 5 years ago. Perhaps could we just start by explaining, perhaps to our younger listeners out there, what Brexit was and how did it happen?
Yes, absolutely. So Brexit describes the phenomenon, the process of the United Kingdom leaving the EU. I'm referring to it as a process because it was, on the one hand, preceded by the attempt by the United Kingdom and in particular by Prime Minister Cameron to negotiate a new membership that encompassed what, legally speaking, are called opt-outs. For our young listeners, simply some exceptions to the application of European Union law. As you may know, the United Kingdom, even before leaving the European Union, was not part of Schengen and didn't use the euro. Despite the fact that the United Kingdom obtained more autonomy, let's say, and the main issue was gaining back sovereignty from Brussels, let's say, so from European Union law, the European legal order, Prime Minister Cameron announced anyway that the referendum was going to be held in June 2016, which happened on the 23rd. As we know, so the majority of people voted to leave the European Union, even though I have to stress that the majority was a little bit tight. And Northern Ireland and Scotland actually voted to stay in the European Union. This triggered Article 50, you probably heard about it, and it's a provision contained in the Treaty of the European Union, which allows a member state to exit the Union. That had never been triggered before. And what it means in practical terms, it started a process, like I said, and the United Kingdom started negotiating with the European Union a treaty, which resulted later on the one hand, on the withdrawal agreement, and later on the trade and cooperation agreement addresses mostly trade issues. But before this, Brexit was delayed many times. At first, the United Kingdom had to send a notification to the European Council to activate Article 50. And let me say that wasn't easy. It took months. So if the referendum happened in June, the notification was sent in March 2017. After that, the United Kingdom was actually given by the European Court of Justice the possibility to revoke the notification in case they had changed their mind. And this was given by the European Court of Justice in December 2018 with the Whitman judgment. Regardless of that, the United Kingdom government, which at the time was led by Theresa May, decided to proceed with Brexit. But Brexit delays, as we will discuss later, were mostly due to the issue of the Irish border. So what are we now? The United Kingdom officially left the European Union in January 2020. There was a brief 11 months, more or less, transition period. And after that, the United Kingdom is officially a third country with some piece of legislation of EU law that still apply. We will talk about that later. And it's our only former member state that left the EU. It's a unique case in the EU history.
Yeah, and it's something that a lot of us still look back on with some regret. The fact
We
that Britain did leave the European Union, including people in Ireland who might have mixed feelings about their neighbour to the east. So let's talk about that more in detail. So this question, a lot of people will remember that during the Brexit process, the question of the Irish border was probably the most contentious issue in the whole of the Brexit negotiations. So can you explain why the border on the island of Ireland was so difficult to resolve?
Absolutely. Thank you for this question. Okay, I'll connect it to my previous answer. Why Brexit was delayed? When the negotiations started, the European Union and the UK negotiators around 2018 already said that the majority of the withdrawal agreement was already negotiated. But what was the problem? Northern Ireland. And that's why Brexit was delayed extensively. So I would frame it in two big issues. On the one hand, peace, and on the other hand, trade. As we know, a conflict affected deeply only 30 years ago the island of Ireland. And that was frozen by the Good Friday Agreement in 1998. So Brexit raised a big issue of respect of the Good Friday Agreement. The Irish border was the main issue in Brexit because the main goal was to keep peace and stability in the island of Ireland. And the only way to do that was avoiding a hard border on this island. This is the only way to keep peace, and also, honestly, Irish people from both sides really deserve to live their life not thinking about what happened 30 years ago. In practical terms, there's also in trade terms and in economic terms, the fact that there is not an hard border keeps the North-South cooperation in terms of stability and prosperity ongoing. But what does it mean for the European Union single internal market and the UK's single market? Well, we had opposite interests on that side. At the beginning, the so-called backstop was proposed, so the entire United Kingdom could be in the EU's customs union. But that, of course, was unacceptable for the unionists.
And just for the listeners, that was, if people might remember, when Theresa May was the Prime Minister, she had a deal that was rejected several times by the British Parliament. And then that was superseded by the deal that was negotiated by Boris Johnson. So and then that got rid of the backstop and introduced new arrangements. But just to explain to the listeners, if they might remember the turmoil of the Brexit years, just to kind of put that in the historical context.
Exactly,
anyway,
thanks.
Please carry on.
Yeah, this is why the agreement was rejected 3 times, and it ended the government of Theresa May, who was followed by Boris Johnson. And that is it's good that you mentioned it, because Boris Johnson was the prime minister who actually got Brexit done, in the sense that the Northern Ireland Protocol was adopted. But in the immediate aftermath, he also declared that he wasn't going to actually implement it. And I'll go into it. So the problem was that keeping the United Kingdom and or only Northern Ireland in the EU's single market, in the European Union single market, was a threat for the unity of the United Kingdom, constitutionally speaking, on the one hand, and on the other hand, on the economic trade side, it was a threat for the unity of the UK's internal market. So, to be brief, what happened with the Northern Ireland Protocol was that there is a border de facto, which means an invisible border, not a hard border, in the Irish Sea. And there is a system of checks of goods that are going from Great Britain to Northern Ireland, with some differences. that were later on introduced by the Windsor Framework. What's the Windsor Framework that you probably heard so much about it in the news? It's a set of arrangements that basically updated the Northern Ireland Protocol. Like I said, Boris Johnson was the Prime Minister who got the Northern Ireland Protocol approved on the one hand, but on the other hand, he had zero intentions of applying it. That was clearly from his political declarations. So that was when the European Union, after a phase of stallment, had to intervene. And politically speaking, I think you might agree on the fact that Prime Minister Sunak really helped with the Windsor Framework.
Right. Yes. So to bring things up to date, so it was in 2023 that the Windsor Framework,
Exactly, February.
under Prime Minister Rishi Sunak, they finally agreed the Windsor Framework, which has essentially amended the Northern Ireland Protocol and made some adjustments to the original Brexit deal, and that was and that more or less settled the issue, even though a lot of people in Northern Ireland continue to be unhappy about it. So people have heard these terms, the Windsor Framework, the Stormont Break, the Irish Sea Border. So can you just kind of explain the trading arrangements and the governance arrangements of this Brexit deal as it concerns Northern Ireland, Ireland, and Great Britain?
Absolutely. So once we established that the Irish border was an issue, so we couldn't contemplate an hard border on the island of Ireland.
And just sorry to interrupt. So because the United Kingdom is leaving the European Union, and so that means that there is going to be a land border between the United Kingdom and the European Union, and that is between Northern Ireland and Ireland.
Which is an external border for the European Union.
Exactly.
Which, calls for special arrangements in terms of application of EU law. Yeah.
But carry on.
Oh, yeah. Thank you. So what did they establish? I'll go chronologically from the Northern Ireland Protocol to the Windsor Framework and then some specific provisions and novelties of the Windsor Framework. The Northern Ireland Protocol, in terms of trade, established that Northern Ireland goods moving from Great Britain, means England, Wales, and Scotland, to Northern Ireland were going to be subject to checks, custom checks. Why? Because some goods were at risk of being brought into the European Union, like Ian mentioned, through the Irish border. So that required a higher level of checks. In legal terms, but also in practical terms, this means creating an asymmetry between trade that goes from Great Britain to Northern Ireland and vice versa. Vice versa, no questions asked. The United Kingdom, 3 of the 4 constitutional states of the United Kingdom are on Ireland, so there was no way that goods going from Northern Ireland to the rest of Great Britain were going to be brought into the European Union. In practical terms, for the lives of the Irish people on both sides of the border, this means that the checks on goods and paperwork were going to delay trade and were going to threaten the now North-South cooperation that they established after 1998. So this was a practical, everyday life problem. In fact, the unionists were not happy about it, and honestly, businesses and companies experienced some issues in applying practically the Northern Ireland Protocol. So later on, there was a phase of stallment of application of the Northern Ireland Protocol. Imagine you wake up in the morning, you have a small business, and you really don't know what to do if you have to carry goods from the Republic of Ireland to Northern Ireland and vice versa. So this was a people's problem, really. And how they tried to unlock it and fix it. So in February 2023, they said, when I say they, I mean UK and the EU's negotiators, and from the UK side, the Prime Minister at that point was Rishi Sunak. And they decided to amend a little bit the Northern Ireland Protocol, which with a set of arrangements called the Windsor Framework. I just want to point out that they actually took advantage of the governance structure set up for the withdrawal agreement. What does it mean? It means that the withdrawal agreement of the UK set up a series of bodies to take care of the implementation of the withdrawal agreement. Imagine that a former member state is leaving the European Union, so it's no longer represented in the European Parliament at the EU level. And new institutions, bodies, committees are needed to look after the implementation of this new international treaty. This is what happened. And it is important in the context of the Windsor Framework, because the Windsor Framework was discussed within the Joint Committee. The Joint Committee was the only one that could actually amend the Northern Ireland Protocol. But what were the main novelties compared to the original version of the Northern Ireland Protocol? When I say original, I mean the one adopted and not the ones rejected by the British Parliament, okay? We have novelties about trade and the so-called Stormont break. Let's start with trade. Okay, I described the asymmetry in trade. What happened with the Windsor Framework was that they tried to ease the checks and controls of the goods going from Great Britain to Northern Ireland. How? By dividing the goods into two main trade flows. On the one hand, the green lane for goods that they were stopping their journey in Northern Ireland. So in that case, the checks were at the bare minimum checks, bare minimum paperwork. And on the other hand, a red lane for goods that were going to be brought into the Republic of Ireland, meaning into the European Union. So this was the practical solution that they adopted for trade. But the main novelty and the reason why the Windsor Framework is so very well known is the Stormont break. So basically, the Stormont break is a clause for democratic, so some sort of democratic safeguard. It allows the Northern Ireland Assembly to stop, yes.
Which in the Northern Ireland, just to explain, Stormont is the name of the
building.
Is the building that the Northern Ireland Assembly is located in.
Yeah,
Carry
thank
on.
you. I always took that for granted. It's a democratic safeguard. Why? You probably noticed by the way I described the trade that at the end of the day, some provision of EU law still apply partially in Northern Ireland. We don't have a hard border. We managed to avoid that. Good job. So peace and stability are secured. But there is an invisible border, and it's in the Irish Sea, because we have the red lane for those goods that are going into the Republic of Ireland. What happens if a provision of EU law that still applies in Northern Ireland is amended? Or if there is a new piece of EU legislation that can be applied to Northern Ireland because of the protocol? The only way that the Parliament of Northern Ireland, the Assembly of Northern Ireland, sitting in Stormont, has to safeguard its democratic representation in this issue is the Stormont break. So it's a mechanism through which the Northern Ireland Assembly can stop, temporarily at least, so it gets checked, the application of new or amended EU law that can apply in Northern Ireland. There is a problem. It is very difficult to trigger and even more difficult to fully adopt it. Why? Okay, technical reasons, but very easy to understand, I swear. It needs to be triggered by at least 30 members of the Northern Ireland Assembly, and they have to be from 2 or more different parties.
And 30, that's 1/3 of
yes,
the
one
members
third
of the Assembly.
That is a lot.
Yeah.
Qualified majority. And also they have to be from different parties, which shows, I think, that Northern Ireland has always had the special arrangements in terms of, representing all the communities. I'm thinking of the power sharing mechanism somehow. Yeah. But another condition is that the government and the assembly have to be fully functional. So that proved to be a problem in this last couple of years, even longer. So it's very difficult to trigger. And even if they tried recently between December and January, I'm talking about December 2024 and January 2025, still there are other procedural conditions. On the one hand, it has to regard only new or amended EU legislation that impacts the daily life of people in Northern Ireland or trade, but massively. It has to have a significant impact. And let me tell you that many scholars commented that that is a very broad concept. What does it mean? I mean, in terms of high effect on people's life. On the other hand, there must be a justification. So let's say the case of December 2024, the 35 members of the Northern Ireland Assembly actually tried to trigger it. And the case specifically was on labeling of chemical products. But then they have to notify it to the United Kingdom, which should write a justification for this and eventually notified it to the European Union. The United Kingdom decided not to do so. And even in that case, if one day it will happen, then the European Union has to, within the joint committee, this is why I really wanted to explain to you how the joint committee works, if that justification is enough to trigger the storm break.
Right. Well, thank you for that. That's really an excellent explanation of, I think, which is it's complex, but I think very important topic. Now, let me broaden our conversation a little bit and can I ask you a bit more about your research? Because you look at Brexit as it has affected not just Northern Ireland, but also two other places, Gibraltar and Cyprus. Now, what is the connection between these far-flung territories in different corners of Europe?
Okay, thank you for asking, because many people actually heard about Northern Ireland, but never heard about the fact that Gibraltar and Cyprus are somehow involved in Brexit. So, first of all, let me start by saying that there are special protocols concerning Gibraltar and Cyprus, and they are attached to the withdrawal agreement. So they have the same legal status of the withdrawal agreement and basically the same legal status of the protocol of Northern Ireland. You might wonder why this protocol exists and what are they regulating. So Gibraltar is an overseas British territory, and in Cyprus, which is a former colony of the UK still detains two sovereign base areas, military base areas. So what they have in common is that these three territories were affected by a conflict that was somehow frozen. And this calls for, let's say, peculiar law enforcement. This always happens. I'm taking into account these three territories at the moment, but if you look around in the legislation of conflicted territories, law enforcement might turn very difficult, but I'll explain this a little bit better. And of course, they have in common also the legacy of the United Kingdom. Gibraltar. So I think Gibraltar in my research has been, I don't want to say the most interesting one, but the surprise for me, for sure. Because Gibraltar is, like I said, an overseas territory that was ceded in 1713 with the Utrecht Treaty. But in terms of geography, this treaty doesn't really contain maps of Gibraltar. So the borders have been contested. And the political tension between Gibraltar and Spain have been going on for like ages, since forever, I'm telling you. It might surprise you that even though they were in the European Union together for quite some time, that eased, of course, the political tension between the two, and it was brought again by Brexit. But still, it was difficult, and it is still difficult to apply the Gibraltar Protocol. Why? The political tension over the Spanish claim is very dense, and it's still there. Just to give you an example, the Gibraltar Protocol has been very slow in implementation, and in June of this year, 2025, they moved a little bit forward. There are many issues that need to be fixed by adopting other international treaties and international standards before that the Gibraltar Protocol enforcement can be done. To be more specific, Gibraltar has an issue with Spain concerning fiscal residencies of businesses and of people. And in order to implement the Gibraltar Protocol attached to the withdrawal agreement, they signed in 2021 a specific international agreement that sets up rule on fiscal residencies. While in June 2025, they finally moved forward on the border issue. So what is the issue of the border between Gibraltar and Spain? Many workers, about 15,000 a day, go from Spain to Gibraltar and vice versa. And they can't possibly go through checks every single day. So in the immediate aftermath of Brexit, it was proposed a partial extension of Schengen to Gibraltar. This basically never happened until June. Let's say they started discussing it again for one main reason. On the one hand, Gibraltar wants to control the border. On the other hand, Spain wants to do it. So they finally reached a dual check solution. On the European Union side, the Spain will conduct the checks. And on the Gibraltar side, of course, the local authorities, which have a high level of autonomy from the United Kingdom. This, of course, doesn't concern workers. Workers that cross La Linea, that is called the border between Gibraltar and Spain, will go through it without checks. And this was a very, very important agreement that they reached after 5 years since the United Kingdom left the European Union. So we have this issue, fiscal and financial issues, mostly about tax residencies, but also smuggling of tobacco products, money laundering. So all these issues can be fixed. And there are premises, like I said, to implement the protocol only through other international agreement that Gibraltar has to sign to comply with international legal standards. So, again, what do we have in common with Ireland? A contested border. And let me connect the two by saying that the role of the European Union was very important in terms of peacekeeping. And this is why after Brexit, we all feared that the conflict were going to be brought up again somehow. Moving to Cyprus. So Cyprus has the British legacy, very, very visible still even for younger generation of people in Cyprus.
Sorry to interrupt. So the visitors know, Cyprus, so the listeners know, Cyprus was also, like Ireland, was a British colony.
It was a British colony, yeah. It was a British colony till the 16th of August 1970. And what I found peculiar as a scholar, a legal scholar, is that the establishment of the Republic of Cyprus was actually signed by the United Kingdom. The United Kingdom is one of the guarantees of peace, stability, and unity. Yes, I said unity, that is very funny, of the Republic of Cyprus. So in terms of legal legacy, that is very relevant. The United Kingdom left Cyprus, but they agreed in these treaties that established the Republic of Cyprus to leave to the United Kingdom 2 sovereign base areas, military base areas. So when Brexit happened, the question was, what are we going to do in terms of movement of goods and movements of people? Again, we have borders. And what's the peculiarity of Cyprus is that the borders are not just between the sovereign based areas and the Republic of Cyprus, but part of the island is occupied, and Turkey established the Turkish Republic of Northern Cyprus. In that specific part of Cyprus, European Union law doesn't apply. that has been established by a protocol that is attached to Cyprus Accession Treaty. Technically speaking, it's called territorial suspension of the acquis communautaire. Practically means that in Northern Cyprus, European Union law is not applied. So when it comes to Brexit, the problem is that who carries on the checks between the sovereign-based areas for those portions of the sovereign-based areas that share a border with the Turkish part, the Turkish side, let's say. It is a very interesting case, I think, because the protocol concerning the SBAs has basically a succession of legislation, experienced a succession and layering of legislation. At first, in 2003, 2004, when Cyprus joined the European Union, so 2003, the negotiations, a protocol was attached to the accession treaty establishing that the sovereign-based areas were going to be in the EU customs union. And that protocol has been basically copy-pasted into the Cyprus protocol attached to the withdrawal agreement. So it's the less controversial case in terms of implementation because the authorities are in very good relations with the United Kingdom. But technically speaking, it might get very complicated. So there are no checks on goods being brought into the sovereign-based areas because it's custom union of the EU. But Cyprus is not in Schengen. And so Gibraltar before this agreement wasn't in Schengen. And even now we're just talking about a partial extension of Schengen. And in terms of checks of people that can go in and out, well, it's mostly people working for the sovereign-based areas. So it's a dual situation between the Republic of Cyprus and the authorities, the British authorities of the SBAs, except for the external border. Again, like the border in Ireland is an external border for the European Union, let's take into account that the border of the SBAs, between the SBAs and the Turkish part, is considered an external border.
Right. So that's very interesting, and people will see. And just to explain to people, Schengen is the area of passport-free travel in the European Union, and Ireland is outside of Schengen, and so is Cyprus, and so they have that in common. Now, I'm going to broaden out the conversation even more. I wanted to introduce an academic concept that I'd like you to explain. What is external differentiated integration?
Okay. So I'll start with a very basic concept. Differentiated integration. What is it? European Union law is not applied equally at the same level everywhere in the European Union and in some third countries. So differentiation means a different level of adherence to the European Union law, acquis communautaire. It's called the group of legislation concerning the European Union. But let's say European Union law is not applied necessarily equally within the European Union, and that is internal differentiated integration. Differentiation can be in time, in space. Let's think about Croatia that joined recently Schengen, and they worked on the Eurozone. They didn't join immediately the Eurozone, for instance. And the United Kingdom, when it was a member state, wasn't part of Schengen and wasn't part of the Eurozone. So that is differentiation. Some policies of EU law do not necessarily apply equally among a member state. And this is the case of internal differentiated integration. But for the purpose of my research and this conversation, we will focus on external differentiated integration, which I think is even more peculiar because we're talking about the application of European Union law outside its borders. So for some reason, that can be political, that can be economic in terms of market integration, fostering democracy, secure peace and stability. Some third states might decide to join some provisions of European Union law, some policies. Brexit proved to be a case of external differentiated integration. I personally argue that that wasn't their goal. They just wanted to get rid of the European Union law. It was very clear in the political conversation. I guess there is no way after all this time to sugarcoat this. They really wanted to stop applying European Union law, and they really wanted to get rid of the jurisdiction of the European Court of Justice. However, in particular, the cases of Northern Ireland, Gibraltar, and Cyprus proved that some provisions of EU law, strategical, functional application of some provisions of EU law, was necessary to keep peace and stability in those previously conflicted, contested, claimed territories. Other examples that go beyond Brexit of external differentiated integration, you mentioned Schengen. Not all the member states are in Schengen. Ireland and Cyprus are not in Schengen. Romania and Bulgaria slowly started joining Schengen. It's a partial integration in that regard. This on the internal side. On the external side, there are some states that are part of Schengen but are not part of the European Union, like Norway. So that's another example of external differentiated integration.
Right. And of course, Northern Ireland that relates to Northern Ireland because so much of EU law continues to apply within Northern Ireland for the reasons that you've explained. And that brings us around to my final question, which is about Ukraine. So I understand that in your future research, you're going to look at questions of EU enlargement, specifically looking at Ukraine. And how does that relate to your previous research and to this concept of external differentiated integration?
Okay, so yes, I would love to move to external differentiated integration and enlargement, because I think that the activation of Article 50 really showed that there are alternatives for being orbitating at least around the European Union. Again, I personally argue that that wasn't the ultimate goal of the United Kingdom, but this is the case. In more simple terms, in the immediate aftermath of Brexit, we all feared the domino effect. But not only it didn't happen, and now I guess that everybody can easily say that that is not going to happen anytime soon. But the technicalities of Brexit, even though it was very painful to adopt and stressing for the scholars, let me tell you, it was very stressing to follow the debate around the Northern Ireland Protocol. It was difficult to adopt it and to apply it. But the flexibility, the creativity regarding legal solutions showed us that we can go beyond the treaties. And how is this relevant for enlargement? So, if you're not familiar with European Union law provisions regarding enlargement, Article 49 of the Treaty of the European Union is specularly the other side of Article 50. If you want to join the European Union, there is a process to go through. And in 1993, the so-called Copenhagen criteria were set up. States that want to join the European Union have to respect some criteria, economic criteria in terms of market integration, and they have to check basically if the economy of the prospective member state can handle the single market and the currency. I don't see, honestly, right now how in the future other member states will opt out from the Eurozone, but we can discuss that later. It was possible for the United Kingdom, but it doesn't mean that it will be possible in the future for other states. They also should show the democratic criteria, so democratic, fully functional institutions, respect of human rights, a high rule of law standard. I will say a little bit more about this later. And I think that after the enlargement of 2004, it was difficult in the European Union to talk about enlargement again. For 2 decades now, we hadn't talked about enlargement. We were all scared because of the democratic backsliding that happened in Hungary and Poland. So even though some prospective countries, Ukraine, were trying to integrate with the European Union, we were just too scared to talk about it. However, the invasion of Ukraine showed that the EU enlargement is an instrument to foster integration, peace, stability, and security. And many scholars have been arguing that now we're switching from the democratic political side of the enlargement, the criteria of the enlargement, to the strategical one. We strategically need Ukraine to join the European Union. But why I went so long on the Copenhagen criteria? Is this feasible according to the Copenhagen criteria? Because a state shouldn't be at war. And this connects me with the example of Cyprus as well. So I honestly don't see the legal feasibility of a full membership of Ukraine because of the war. If we apply black letter the Copenhagen criteria, that cannot happen for a country at war. And you may probably wonder how come that happened for Cyprus. Well, Cyprus has special arrangements. To start with the context, the conflict in Ukraine is still ongoing. We all hope that it will end as soon as possible for Ukrainian citizens, but it's still ongoing. In Cyprus, in 2004, when Cyprus joined the European Union, the conflict was stable and basically frozen. Legally speaking, the protocols that I mentioned establish that the EU acquis communautaire, the EU law, is not applied in northern Cyprus. So there's a suspension, and this is the legal condition that was established to overcome the obstacle of the Copenhagen criteria. My hypothesis to extend my research from Brexit to EU enlargement is applying the flexible legal tools that were applied to manage Brexit, so external differentiated integration, as I explained, in practical terms means either applying European Union law extraterritorially or establishing in, let's say, association agreements, clauses of law. They're called the clauses of approximation. Approximation to what? European Union law. Let's say imitate as much as possible European Union law to apply it externally. This proved to be a creative, flexible legal solution to manage Brexit, especially in the case of Northern Ireland, Gibraltar, and Cyprus. And what I would like to do is to translate that, to move it to the application of Article 49, in particular to the case of the Ukraine's enlargement. Why? My hypothesis is that given that the Copenhagen criteria might need some updates in legal terms means treaties reform. We don't have the political condition to do the treaties reform right now. At the same time, Ukraine probably can't join fully the EU because of the ongoing war. So, we strategically need Ukraine in the EU's orbit of integration. So, what can we do? I think that EDI, external differentiated integration, might be a feasible way to integrate Ukraine through a so-called nuanced or staged membership.
Well, I think that's a hopeful note to end this conversation on, because it's talking about the possible that even if Brexit was kind of a sad event, then if it provides lessons that could make it easier for a country like Ukraine to join the EU, then that could be one positive outcome of it. So it's nothing left for me to do but just thank you, Jasmine, for joining us today, and good luck with your future research.
Thank you, Ian. Thanks for having me.